There we go.
Heck, I thought that Donald Trump would have been complimented by somebody calling him too small. But what do I know? I just show up and do things. Well, we're going to talk about that scintillating subject of patents. I don't have any pictures of bras. I don't have any pictures of FUCK. So it's more of a, shall we say, a mundane subject than we've been exposed to here by the chipper, who's incredible. So it's a disclaimer. I'm here to entertain you. My wife, we've been married this year in 2 months. We've been married 49 years. She told me long ago, these people don't want to be educated. They want to be entertained. Oh, she's a genius. Why she married me? That's a different question. Okay, so we get the disclaimer. What's been happening? A lot's been happening. Suddenly, the Supreme Court has become more friendly to the federal circuit. That ought to be grounds for impeachment right there. And so here you've got it now, it's 9 out of 34. You say, well, that's only 26%. It's a big jump over what it's been in previous years. So things are coming along. This case, I met Judge Stark last night. He wrote the original opinion on this case. He got pounded at the federal circuit, and then he got pounded again. I was very careful not to raise this case last night, thinking that he might raise something and hit me over the head. So this case is a morass. It is so complicated, and it's very bizarre. The jury verdict, it says, oh, everything's okay. Stark does JMOL. Oh, it's not okay. And then they do a hearing. Oh, well, it goes the other way. Then they do another hearing. Interesting, the same panel. There's no court stacking here. And we'll get into that, judge stack. We'll get into that later. But now there's a petition for cert pending. They've requested the Solicitor General's views. Now, what kind of illumination will that provide for the subject? I have no idea. I doubt they know anything about this, but it'll be interesting to watch and see if the Solicitor General says go. Now, the way the Supreme Court, they're getting prickly, thorny, and argumentative in their old age. And I think if the Solicitor General says, don't hear this, they'll hear it, and vice versa. They like to do that these days. Keep us all on our toes. Now, this Amgen case is a fascinating case. People are screaming and yelling about this case. Amgen, they are a pharmaceutical company who litigates. That's all they are. They're just a litigation firm that makes pharmaceuticals. That's what Amgen does. And they'll say that themselves. I'm not talking out of school. That's what they like to do. They are, shall we say, combative. Yeah, some of your folks in trademarks could learn from Amgen. And so they got this claim here, blah, 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 blah. Who cares? It's an isolated monoclonal antibody. But the jury said, well, gee, you haven't proven that these claims are invalid for lack of written description enablement. And then here it goes, JMOL again. And they say, don't pick it up on written description. But they say, oh, these claims aren't enabled. So there's the petition for cert. There's the petition for cert. And it's kind of like one is the narrow version, two is the real broad version. Oh, amici have gone through the roof. There's all these people filing amici briefs. The law professors are offended. I don't know, Margot, if you filed this case or not, you could do whatever you want. And basically, you had all these people come in and say, oh, this is terrible. And so the Solicitor General was given leave to participate in the amicus curiae. Look, I lost the Helton case 9-0 at the Supreme Court. And the reason I lost is because the government was helping me. And they got him admitted away the whole damn case. And so, whoa, good luck. Good luck. We'll see what happens. So anyway, this is interesting. Now, this is a case got everybody outraged. You got this Novartis versus Accord. And what you've got here is, can principles of sound judicial administration preclude a court of appeals from adding a new judge to form a new panel? Somebody retired. And so it was 2-1 one way in favor of Novartis. And then they do a hearing. The judge retired. I mean, was there money under the table? I don't know. I don't know. Nobody tells me these things. I don't know. But the judge, they appointed another judge. And I was like, whoop, flip. Now it goes 2-1 the other way. Does this stink or what? Court stacking was a big issue in the last presidential election. Kind of sounded like court stacking. Oh, you didn't like that? Just have somebody retire. appoint them to some lifetime position as the curator of the National Zoo. They have to resign and you put in who your friend is. They'll vote my way, getting them on here. Oh, God, we can't get it with just one person. Let's add 2 more people. Let's do a panel of 5. Oh, that didn't work. Let's go 7, 9, 11, and then until you run out of judges. So this is really crazy. Now look who's filed in this. You got the intellectual property professors saying, "Whoa, this is bad. This is bad. We can't have this kind of shenanigans going on." And then you have retired United States Circuit judges. Now, what are retired United States Circuit judges good for? Well, to make a whole heck of a lot more money than they made when they were judges. They're very good at that. And so here they are offended. Oh, this is terrible. And they came in. We'll see what happens. Look, the response is due today. So stay tuned. You'll watch your cell phone. We may find out what they said in response today. And they'll say, oh, it was wrong. So we'll see what happens. Now, this kind of goes with the Amgen case. This is something I didn't see coming because I started in patent law in 1975. Some of you were alive then, but most of you were not. And so in 1975, enablement, written description. Oh, come on, Brian, we knew all the cases. In re Marsoki, in re Angstad, there's no problem. We can handle this. By the way, all those cases that Brian and I used to rely on, they're en banc authority. Because when the Federal Circuit formed in the South Corporation case, they made all the CCBA cases en banc authority. And so being, I'm almost 72. So what do I rant and rail about? I rant and rail about that because there's many people in the audience here who've never heard of the CCPA. Oh, thou ignorant and unenlightened. You've got to become aware. So but you look at the balance there. Look at all the ones that didn't fill the requirements of 112. And I looked at that. Looks like all of them are pharmaceutical cases except one. So if you're in the pharmaceutical area, woohoo, watch out. You may be having a problem. And then you just got a few on the other side. And then, of course, we have the Accord case, our favorite case, switch sides. I mean, hearing this is too good. You can't make this stuff up. It's just too good. Okay, and then 101, I find this ridiculous because the first 35 years I practiced, here's what you did. If you wanted to stay at your city's keys, you're not sure what you're doing. Oh, I got people listening in. I got to stay up here. Okay, so watch the hand. I'm going to drop these keys and we're going to pretend this is grass. Pretty loud grass, right? Okay, now, if the grass grows, it's a fertilizer. If the grass dies, it's an herbicide. And that's how I proved utility all those years. I got away with this. It's pretty darn amazing. A colored pass, I think probably at the end of the speech, Finnegan will fire me. They'll say, oh, God, we had enough of you. You are a moron. And I said, it took you that long to figure that out? 47 years, you couldn't figure that out? What's wrong with you? So this is, I don't know what the answer is. And people say, oh, the answer is to have a political solution, to have Congress. Well, you know my views of the government, like in the Henderson case, when the government showed up and said, we're here to help you. Run this way as fast as you can, because you know you're sunk. They're going to help you. All right. They're going to help you lose. That's what they're good at. So anyway, this is crazy. And it just use the old grass and fertilizer herbicide technique. It works for even mechanical inventions. Drop on the lawn. If it kills, it's herbicide. If it grows, it's fertilizer. It's crazy. But this is another problem. I think the 112, the description enablement, and 101 are kind of the present day scourge of U.S. patent law, particularly if you're trying to get broader claims and you're a pharmaceutical company and you think you need more protection for your drug than just the particular antibody or the molecule. Crazy stuff. Now you're saying, what the devil good is this speech? All you're doing is telling us that the whole system is screwed up. You got it. That's where we are. That's 2023. That's where we stand. Now, legislative response. You can read that. You can guess what's going to happen. It says legislative response to 101 mess. My view would be create a bigger mess and do it legislatively. Government here to help you? I don't think so. Okay, so you got that. That's coming along. Now the Court of Appeals for the Federal Circuit. And look real quick. I don't see any Federal Circuit judges that are here, so I can be unrestrained in what I say. And so here's the great case. Is artificial intelligence an inventor? Whoa, that's a weighty question of 2023. The answer is no so far. and everybody is upset about this around the world. And there's so much going on here. Watch this and see what happens. I don't think that's going to stay forever. Now, the offers for sale, here's where justice comes in. The people that lose out on these, and these are all losses. These are people that lost their rights because they put it for sale more than a year before they filed their US patent application. Why did they do that? Plain and simple. You may say, well, they were stupid. That could have been. But the reason people do this, they're trying to generate revenue, right? They want to make revenue. They want to make money. Don't you think that's a good idea, miss? Making money? I do. I'm a capitalist at heart. I've never been a good communist. Yeah, they threw me out. And so basically, yeah, but see, this is social justice because it seems to me the people that are underrepresented are the people most likely, small companies, they're going to run out there and they're going to basically try to sell their invention. And then, you know, Esther comes along and says, well, I'll file a patent for you. How much will it be, Esther? Esther says $3,000. I know that's your normal rate. And so they say, I don't have $3,000. And, you know, Esther might say something that's really sensitive, like, well, you got a kid you can sell off or something. No, you wouldn't do that. You wouldn't do that. And so this is a problem. This is a social justice problem that I think will solve these problems in lives in being plus 21 years. It's the rule against perpetuities from law school. So I'm not optimistic. Now I'm going to die in 2054 and I'm going to work until 2054. I'll be 103. Will any of these problems get solved by 2054? I'm banking on them not. How am I going to make a living if the problems get solved? Oh, so cynical, so cynical. Obvious as blah, 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 blah. That's good. Now we've had enough. We've had enough of this. And I want to try and get us back. So I give Ian as much time as I can. Let's go. This is new and exciting. And this stuff's all great stuff. And if you're having any trouble reading tonight, or sleeping tonight, read my slides. They'll put you out. And if you're old and feeble like me, and you wake up 2 or 3 times during the night, pull the slides from your bed table, start reading, you go right back to sleep. Not a problem. Estoppel, this is great stuff. This great stuff. And so now it's time. It's time. Just tell me to shut up. Now, she played D1 softball. She has my ultimate respect. Okay, so there's all this stuff here. 3-1. I'm a big expert on 3-1. I think this case is wrong. I made a living out of telling people they foot-faulted into that. Definitive denials, Director Vidal's procedures. I love Director Vidal, you know, because she really gets involved. Now, those of you who've had your wins reversed by Director Vidal, you probably don't share that same love. But oh, I'm so happy to see, and the director's got so much energy and she's so engaged. It's all good. I like it. I like it. Okay. Blah, 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 blah. Are we doing well? Look at this. We're okay. Polling question. Now, here's what's going to happen. You don't get to vote because we couldn't technically figure that out. We have disenfranchised this entire class. So fire on you for showing up personally. You would have been a hell of a lot better off doing this online because then you could have voted. So what we're going to do is I'm going to read the question and Tasha, who's a genius, is going to run the polling question. It's going to appear. The answer is going to appear right up here. And then I may want to comment. You may want to comment. And so they have this modern device called a microphone. If you want to say something, leap to the microphone and say whatever you want to say. The First Amendment lives here. This is a social justice course. You can say whatever you want. Okay, polling question 1. So debates are raging in the US about the breadth of claim scope for written description enabling fundamental principles 112A, particularly in the life sciences where I practice. So here you go. Yes or no? 1, patentees are only entitled to claim what they've done experimentally and nothing more. That's 1. Number 2, particularly in the life sciences and chemistry, patentees should add at least 1 means plus function claim. Okay, if you want to know what that is, I'll tell you later. Patentees should obtain a Jepson claim. That's very interesting too. Or yes to 2 and 3. Okay, turn it on, please, Tasha. Let's have people vote. So all you out there in audience land, vote away. Okay, and we're going to watch the answers come in, which at the moment seems to be like watching the grass grow. Well, it looks to me like the audience is stunned. They don't know what to do. They wanted to know if this was really a CLE presentation, just a joke. So let's see if that can get that going. Okay. We have to watch up here. See if something happens.
Everybody's Googling.
Oh, look at this. Look at this. It's coming in. It's coming in. So we've got 91 to 9. This is a pretty aggressive group. You want to have this ball playing. Okay. Then you got to ask this question. And then with civil life sciences, yes. Now it asked 55%. Do you even know what that is in life sciences? Probably better than you don't. But that's very interesting. Very much like that. Number 3. Can you see the answer? Is there any way we can see 3 and 4? Well, what you got? You can guess the answers. Okay, so what do I think? I think the answer is 4. I think you should. Oh, look, now is it 3 has come in. There we go. 3 is saying a Jepson claim. 64% said no. 36% said yes. And then 4 hasn't come up yet, but I bet 4 will be. My guess is you take those numbers, you divide by 2, you take the square root, you subtract 1, and you'll have the answer to 4. Okay, so I kind of think that doing 2 and 3 is a heck of an idea. And people are doing that for fun and profit now, particularly in life sciences. The mechanical people think the means plus function claims way too narrow. But in the life sciences, it's considered pretty cool. Anybody want to leap to the microphone and say whatever you want to say? We're watching. No takers. Lloyd, if you want to say something, go ahead. You're up there. This is Lloyd, and he runs this whole deal. He's a IT
Teamwork with
genius.
Limero. Test, check. Can you hear me?
Oh, okay. I told you the genius. He discovered that the microphone works. And that's right. Okay, let's go to polling question 2 then. I got to get off in a couple of minutes. We want to hear Ian. So, okay, let's go to polling question 3. That's 2. Okay, you're going to love this. Okay, here's something. Is the Jepson claim risky? Isn't applicant admitting that everything other than the improvement is absolutely, but maybe essentially the amelioration of that risk is may have a whole lot less problem with enablement and written description. So you got to think that through. Okay, question 2. Should the federal circuit, are you going to love this? Should they be able to add judges on a hearing? So the majority then decides, you got to think about this, Judge Bullock. You could do this at PTAB too. You get an answer you don't like, add more judges until you get an answer that you like. Director Vidal should be all over that. She'd love that. That'd be great. Okay, so this is a hard question. Yes or no? Should you be able to stack the panel to get the result that whoever's in charge, like Judge Bullock or whoever's in charge, the result they get? Yes or no? Okay, vote. Let's have a vote real quick and see where people come out on this. Oh, whoa, 27%. Long live anarchy. They're going to go for stacking. Okay, Judge Bullock, you're going to write these numbers down. You may need these. And then no said 73% said no. So we had a 3/4 majority. That is statistically significant, of course. And so they didn't do that. Okay, polling question 3. Okay, now here you got a patent application, number 3. It's entitled to pre-AI priority date. That then in prosecution after March 15, you present a really stupid patent claim, an absolutely stupid claim that does not satisfy written description and or name it. It is a stupid claim. Okay, so now I was a broad jumper. I was not a very successful broad jumper. Because when I was approached a little rubber jump, my toes always stuck over. My toes always stuck over there, and I was told to come back to the microphone. I do what I'm told. And so how else do you end up being married for 49 years? I do what I'm told. So basically, the question is on question 3, can you foot fault into AIA? Remember, there's the thing in the AIA that says claimed at any time. Okay, let's see how you vote. Some people are voting with their feet and leaving. I respect that decision. Okay, we got answers. People are stunned. We're waiting for the answers. Nobody's going to answer. Tasha, oh, look at this. Whoa, we did it. We did it. That is the greatest polling question of all time. We got 50-50. We're going to have either a recount, a re-election, or a special election. I work at this all the time. Rarely do I get a 50-50. So I'm going to go home happy no matter what happens, whether I get fired from the firm or whatever. I don't care because I got a 50-50. Isn't that interesting? That people are saying, it says at any time. So if at any time you present a claim that doesn't have that earlier priority, you're stuck. Okay, real quick, let's go to 4 now and turn it over to Ian. Okay, here, during prosecution, applicant makes an unequivocal admission regarding the priorities, an AAPA, applicant admission rate priority. They say, well, the disclosed blue widget, they're trying to distinguish over it at this point in prosecution. Oh, it's well known in the order, but they don't cite any prior document to support that allegation. They say, no, the blue widget was known. The blue widget couldn't be viable. And then as things go on in patent prosecution, I've had cases that last, 15 or 16 years, long enough to have grandchildren and stuff like that. That's all great. And so then they come back and they actually claim the blue widget and they get a patent on the blue widget. So somebody they run into Judge Bullock's administrative court. They say, well, we're going to file a petition. We think that this claim, this patent should be knocked out because they admitted unequivocally that blue widgets are priority. So here's the question. Can you file an IPR based solely on that admission? It's one of those tricky ones. Yes or no? Okay, let's see the answers come in. Whoa. It's an old age. Okay. 2/3 of you say you could do that. Now, that is contrary to one of the cases and materials that I hid from you by skipping over it, which is what you do with people. You want to confuse them. But that's interesting. 2/3 of you said yes. I would rely, Brian, we'd rely on this in Reino Maya. Brian and I would have relied on that. We would have filed the petition based solely on that admission. And so 2/3 of them say yes. So I think maybe the story is not done here because these are PTAB cases, which of course Judge Bullock is the greatest administrative tribunal in the universe. But what will happen at the Federal Circuit? I don't know. And I so enjoyed being here today. Thank you for your time, and we'll turn it to Ian.